In this tutorial, we study what is meant by evidence and what are different kinds of evidence. Evidence refers to a statement made on oath before court by a witness is generally called as evidence. This evidence can be either oral or documentary. This evidence can be direct or indirect. First, we take up what is the difference between direct and indirect evidence. Let me share with you, law permits only direct evidence to be given before court. Direct evidence refers to person who perceived by his own senses shall come and depose facts before the court and no other person. If any other person deposes fact who has no personal knowledge about that particular fact, his evidence is called as a hearsay evidence. It shall be rejected. It shall not be treated as an evidence. And this rule of rejection of evidence is not a blanket one. There are certain exceptions also. Under some provisions which are expressly recognized by Evidence Act, wherein even though that person did not perceive by himself, still if his case falls within the particular circumstances listed out under our Indian Evidence Act, even though he is a hearsay witness, still he can depose those facts. Those situations are dealt under section 6 of Evidence Act called as res geste. Number 2, admissions and confessions. Number 3, any statement made under the circumstances covered under section 32 and 33 of Indian Evidence Act, and evidence given in judicial proceedings before any person who is authorized to record evidence. Similarly, expert opinion, public documents. Thus, all these situations, those persons, even though they don't have a personal knowledge about the facts of the case, but still, because of the express provisions and peculiar circumstances, still their evidence can be taken and they can be read as part of evidence, even though it is indirect. Now, turning to the next issue of oral and documentary. As I have already told you, oral refers to speaking by mouth before court, whereas a documentary refers to, by way of a documentary form, a fact is placed before court. To put it in one word, documentary evidence refers to anything which is expressed by way of signature, by way of signs, symbols, over a substance is generally called as a document. Law says all facts can be testified by way of a oral evidence. It is not necessary that everything must be proved by way of document only. The question of proving a fact by way of a document arises only if the parties reduced a thing into writing. Otherwise, that fact can be proved by way of oral evidence. Even 1 crore lending money can be proved by way of oral evidence. However, if wherever law says such particular transaction to be in writing or to be registered, oral evidence is not permitted, only in that circumstances, and for that purpose we have to necessarily produce a document. To put it in one word, all facts can be proved by way of oral evidence. Now, coming to the documentary evidence, under Indian Evidence Act, documentary evidence, basing upon the kind and nature of document, we have variety of documents. Let us see what are they. Documents are classified into primary and secondary, new and ancient, attested and non-attested, public and private, negotiable instrument and ordinary instrument, document with ambiguous defect and latent defect. Now, coming to the primary and secondary evidence. Primary means generally the original document itself. Secondary means the copies made or compared from the original. They are called secondary documents. The complete details are not being explained here. For that purpose, we request you to go through section 62 and 63 of Evidence Act. Now, coming to the new and ancient document, all documents which are of less than 30 years of age on the date of tendering it in evidence is called a new document. It must be proved like an ordinary document. It means the person who signed it, who executed it, who know the contents personally, that person shall come and depose facts before the court, then only court can read that document, otherwise it cannot. Whereas ancient document means a 30-year-old document. That, that 30-year-old document can be read in evidence provided to the extent of signature it is containing, but not about the contents. So the basic difference between ancient and new is because of its time of 30 years, generally if it is from a proper custody it would be taken as a proper document, but the rest of the contents must be proved like a natural document only. Whereas under a new document everything must be proved by the person who is relying upon it. Now coming to the attested and non-attested documents. Attested documents means two or more person put their signature on the document stating that the person whose signature is appearing is the one who actually signed it. It is not necessary that attestor must be brought before the court. Only in those situations where attestation is mandatory, in that circumstances, attestor must be brought to prove the contents of the document. Whereas a non-attested document, it can be proved with any other person who executed it, who signed this, who acted as attestor, who is a scribe, who witnessed the transaction. Any person can speak about the contents of the document. And now coming to the another classification, public and private. Public means deeds, deeds of parliament, circulars of parliament are all statutory or administrative written documentary things which are issued by the public authorities or public officers in discharge of their duties. They are generally called as a public documents. The documents which are not called as a public documents, they are called private documents. A private document must be proved necessarily by bringing the person who signed it, who witnessed it, who scribed it, or in whose presence it is written. Any one of the person can testify, then only the court will read the contents of the document, otherwise it cannot read the contents of a private document. It is like a white paper. If any of this person did not turn up before the court and testify before the court. Whereas in case of public document, any person, irrespective of his connection, he can directly file it. The mere filing and marking would enable the court read a public document. That is the basic difference between a public and private document. Now coming to the instrument, negotiable instrument. The term instrument indicates a document through which a right or liability is created. Negotiable instrument means we have three kinds of negotiable. Number one, pronote, check, bill of exchange. Section 118 of a Negotiable Instrument Act says once a negotiable instrument is execution is proved, the court shall presume its valid consideration, date, time, place, everything as a correct. So in case of negotiable instrument, once execution is proved, we have many benefits. In other words, the burden shifts on the opposite person who disputes the genuinity of the negotiable instrument, whereas other instruments, everything must be proved by that person. And lastly, coming to the latent documents with latent and patent defects. If the document contains a patent defect, it cannot be cured. It is a useless document. A latent document is an invisible document. By producing some external oral evidence, if the document can be rectified, that is called a latent document. These are various kinds of documents which are provided in the Indian Evidence Act, which are very much necessary to know to deal with the various kinds of documents and placing evidence before the court. That's the end of evidence and various kinds of evidence. Thank you.